Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Morning, counsel.
Good morning, Your Honor.
What brings you here?
LAFCU v. Carrie Crump.
Okay. Let's see if I can get her connected. We can get started.
Thank you, sir.
Connecting up now. Did not connect. All right, I think we have her now. What is your name, ma'am?
Carrie Elizabeth Crump.
Good. We have everybody. Let's call the case. This is 23-140-351. LAFCU versus Carrie Crump. Date and time for what appears to be our second pretrial appearances.
For plaintiff LAFCU, Tim Smith, P48259. Good morning, Your Honor.
Good morning. And your name is Carrie Crump, ma'am?
Yes.
All right. We were last together on this file on March the 7th. At that time, the court opened your written discovery. How are we doing on written discovery?
We immediately filed written discovery, Your Honor. Answers are not quite due yet. We anticipate upon receipt filing our motion for summary disposition in the matter. You allowed us to chat in a breakout room so that I could have a better understanding, or each of us could have a better understanding of our respective positions. It was my understanding, I don't want to speak for Ms. Crump, my understanding from that conversation was that she took issues with the dealership, how the dealership handled the transaction. There were no complaints leveled against LAFCU itself, who is the party. The time period for third-party practice at this point is long since passed. They are not joined as a party, but I'll flesh that issue out more once I file my motion for summary disposition.
Ms. Crump, are you planning on doing any written discovery?
Well, I can.
It's up to you, ma'am. You can't. You have a right to do so. If you're going to do that, you need to get started on it. So what I'll do is I'll continue your written discovery. I'll give you a return date with me of May 2nd. May 2nd at 10 o'clock. It'll be on Zoom like today. Does that work for everybody?
Yes, sir.
Yeah.
Okay, May 2nd
May
at 10 o'clock. Your written discovery will continue. Is there anything
Thank
else
you,
you can accomplish today?
Nothing for the plaintiff, Your Honor. Thank you.
Anything for you, ma'am?
No.
Okay, thank you both for coming in. We're off the record.
Thank you, Your Honor.
Thank you, sir. Morning, counsel.
Good morning, Your Honor.
What file do you have today?
I have case number 22-193-860, General Civil, John Kane versus Elizabeth Street Lofts.
Oh, you're not on my docket today.
Not?
That's not till 11 o'clock.
Oh, I did that again.
Come back.
10 o'clock instead of 11 o'clock.
Yeah.
Did that last time too.
I know, you're at 10 o'clock now. You want to be at 10, but you're at 11.
Okay,
I'll put you back in the waiting room.
okay. I'll leave and join back in an hour. Thank you.
I'll remove you then.
Okay.
Hello,
Hello, what is your name?
Tamiko Polk.
Tamiko Polk?
Yes.
All right, let's get started. Give me just a second.
Okay.
Mr. Saloon,
Good morning, Your Honor.
I think I have both sides. Let's get started. All right. We are on the record calling file number 22-192-478, Discover Bank versus Tamika Polk. Date and time for motion for summary disposition filed on behalf of the plaintiff. Your appearances.
Good morning, Your Honor. For the record, William Saloon, P41487, appearing on behalf of plaintiff.
And what is your name, ma'am?
Tamiko Polk.
Ms. Polk, did you file an answer to this motion for summary disposition?
No.
Okay, counsel, your motion.
Thank you, Your Honor. Your Honor, we filed a motion based upon MCR 2.611 C10. Indicate-
2.116.
I'm sorry, what did I say the site
I
was?
said 2.616.
No, I got, I'm sorry, Your Honor. It's 2 point, I think it's 2.61.
It's 2.116 C10, counsel.
C10. I'm sorry, Your Honor. I don't have that in the actual in front of me. We're indicating that defendant filed an answer with general denials. She fails to state a defense. We filed a complaint based upon an affidavit of account stated alleging a sum certain being owed, that amount being $10,230, with court cost of $291.54. Plaintiff is asking the court to enter judgment as a matter of law in the amount of $10,523.61, as there's no triable issue for the court.
Counsel, I'm looking at your complaint. I do not see an affidavit. I do not see an affidavit in your pleadings.
It may be in the the motion itself. May have been
In your motion, you did not supply an affidavit. In your motion, I'm looking at the judge's copy. You provided a list starting with your exhibit A. I saw your brief in support. I saw the exhibits that you provided, but I did not see an affidavit. Can you point me to it, please?
yeah, just a second, Your Honor. I'm sorry. I'm going through it right now, Your Honor, to see if I can locate it.
Yeah, that'd be great. Because I've gone through it and I can't locate an affidavit.
It in my packet, Your Honor.
I'm sorry?
I don't see the affidavit in our motion. If it wasn't filed with the complaint in the court file, I don't know why it isn't there.
There's no affidavit either in the complaint or in your motion.
Yeah, I don't have a copy, Your Honor. I'm sorry.
The court is going to deny your motion for summary disposition. It's failed to be supported by affidavit as is required by MCR 2.116 C10. Court will send out an order denying the motion for the reasons set forth on the record.
Your Honor, if we could resubmit a motion with if we're able to locate the affidavit of account stated.
Counsel, I can't tell you how to practice law,
Understood, Your Honor.
but this is sloppy lawyering. You're not aware of the court rule under which your motion is brought. You claim to have affidavits that you didn't have in the complaint, claim to have affidavits that you didn't have in support of your motion. This is not good lawyering.
Yeah, I apologize, Your Honor.
The motion is denied for the reasons set forth on the record. Next pretrial date will be May 2nd at 10 o'clock. Ma'am, if you want to file an answer to this motion for summary disposition, I would urge you to do so promptly. You must serve a copy on both the court and on the attorney for the other side. Thank you both for coming in. We are
Thanks.
off the record.
Have a good day.
Thank you.
Thank you
Bye-bye.
both. Sloppy lawyers, counsel. Hello?
Yes,
What is your name?
Tammy Walton.
All right, hold on for just a second. All right, we are on the record calling file number 231-40007. Credit Corporation Solution versus Tammy Walton. Date and time for what appears to be our second pretrial. Could I have your appearances?
Judge, may it please the court, I'm attorney Richard Gruson. My bar number is 35222. I'm the attorney of record for the plaintiff, and I'm also the attorney for plaintiff in this pretrial.
And what is your name, ma'am?
Tammy Walton.
All right, we were last together on this file on March the 7th. At that time, the court opened your written discovery. How's that coming along?
Judge, may it please the court, I can tell you as an officer of the court that I have received in my mail yesterday, a signed copy of a consent judgment, which I have countersigned prior to the court taking the bench today. And defendant will consent to the entry of a consent judgment in the original amount of the complaint, which was $1,131.86, plus statutory costs of summons filing fee, summons service fee, total costs of $82.97, a statutory $75 attorney fee for a total judgment of $1,289.83. Concurrently with the entry of this judgment, there is a installment payment conditions whereby defendant will pay $50 per month beginning March 24th, 2023. I have signed that, defendant has signed it, and I will file this judgment with the court either Wednesday, which will be the last working day of the court, or next week, Judge.
Okay. Ms. Walton, you heard all of those terms?
I did, and I have made my first payment already.
Already?
And we'll be making a second payment Friday. Well, getting the money order Friday when I get paid.
Good for you. All right, then what I'll do is I'll dismiss the matter without prejudice. Note for the record that a consent judgment will be filed. Thank you both for coming in. Appreciate your time.
Thank you, Judge. Plain
Be
press.
safe out here.
Thank you.
Thank you, ma'am.
Hello, lawyer. Hello, lawyer.
Rusen, hold it.
I am here.
I wanted to ask him a question.
Hang on. Let me
Okay.
put you guys into a chat room so you can do this between the two of you, not everybody on the internet. Okay?
Thank you.
All right, hang on.
All right.
So also I wanted to
Hang
know
on,
about
wait, wait, ma'am. Wait. Damn. There you go. Hello?
Good morning.
Good morning. Not getting the other side here. When we get the other side in here, we can get started.
You said you don't see me?
No, I said, let me get the other side and we'll get started.
Okay,
I can see and hear you.
okay.
All right, Ms. Francis,
Good morning, Your
Hi.
Honor. I apologize. I was in the wrong courtroom.
this is 22-198-388 Woodbridge Estates versus Janae Lindsay. Could I have your appearances?
Nalchat Francis, P72322 on behalf of Plaintiff's Attorney of Record.
And your name, ma'am? Ma'am, what is your name?
My name is Janae Lindsay.
Okay, this is our second pretrial. The court, we were together on March the 7th. The court opened your written discovery. How's that coming along?
Your Honor, we did send discovery requests. I believe they're still outstanding. But the 28 days has not expired. So
All right.
we're just asking for discovery to continue.
All right. Ms. Lindsay, are you planning on doing any, sending out any discovery requests of your own?
I was asking, can I get a lawyer? Because I don't understand. I guess I thought I could.
Ma'am, this is a civil case. The court does not appoint lawyers for sides in the civil case. That's only
Okay.
in criminal cases.
Okay.
You might want to try the State Bar of Michigan. You could try the Detroit Metropolitan Bar Association, both Wayne State and U of D Mercy also have clinical law programs where perhaps you could get free counsel. But you only get a free lawyer in a criminal case, and this is a civil case.
Okay, I did receive the paperwork. I did receive it. I came down to court because I didn't know if I was supposed to fill it out. The
Yes, ma'am.
discovery-
You have to respond to the written discovery request and send your answers to the attorney for the other side.
Okay,
All right, so we'll continue your written discovery then. We'll give you a return date. Your next date with me will be May 2nd at 10 o'clock. Your written discovery will remain open. Is there anything else we can accomplish today?
yes, I need, okay, so
Ma'am, go ahead.
when you say written discovery, I just need to, the questions that they send me, I just need to correspond to them and send it back?
You need to respond to the written discovery requests they have, and you have a right, ma'am, to send written discovery requests of your own as well. That's up to you.
Okay.
We'll see you again May 2nd at 10 o'clock. We'll be on Zoom like today. Thank you all for coming in. We're off the record.
Thank you, Your Honor.
The great musical mysteries of all time, the mystery theme that remains unheard, and the enigma variations. Yeah, he was really Jesus, so it was 36 music. Pierre Monteur and the London Symphony Orchestra have discovered Elgar, listener supported WRCJ-FM and HD1 Detroit. Support for WRCJ is provided by the Detroit chapter of the American Guild of Organists. It's been called the King of Instruments, and Beethoven called organists the greatest of all virtuosos. The AGO is a national organization, and the Detroit chapter is one of the largest in the country, first founded in 1910. Information is available at detroitago.org. Facts about our next composer, who was born in Los Angeles in 1900. He lived until 1991. Her mom was a pianist who studied with a pretty famous pianist named Franz Liszt. You may have heard of him. Yeah, that Franz Liszt was the teacher of Eleanor Remick Warren's mother, whose dad was a fine singer. In fact, she was a published composer with the Sherman Publishing Company. Before high school graduation and afterwards became a composer and concert pianist. 5 facts about Eleanor Remick Warren. Here's her symphony in one movement. We're on Scottish. Symphony in One Movement, 1970 work by the American composer from Los Angeles, Eleanor Remick Warren, who lived from 1900 until 1991. The Royal Scottish National Orchestra played the Symphony in One Movement. This was supported WRCJ FM HD1 Detroit. Listeners supported WRCJ with the music entitled The Nightingale in Love. Yeah, they're probably feeling it here. Francois Cooper has music. Angela Hewitt was feeling it. She was out music. Francois Cooper is supported WRCJ FM with Chief and Intro.
Counsel,
Good morning, Your Honor. How are you?
I'm not bad. How about yourself?
I'm doing all right.
Get Ms. Madden in here, since she came at 10 o'clock. We'll get started. I guess she's anxious. This is file number 22-193-860. John Kane versus Elizabeth Lost. We're here today for a pretrial as well as a motion to dismiss filed on behalf of Elizabeth Lost. Could I have your appearances, please?
Peggy Madden, P39308, on behalf of the plaintiff.
Good morning, Your Honor. Sean Riddell, P81302. I'm actually appearing on behalf of the plaintiff counter defendant in this case.
Oh, pardon me, Your Honor. That's absolutely correct.
It's reversed from normal.
I'm used to saying plaintiff, so.
You're lost today. Ms. Madden, I believe this is your motion.
It is, Your Honor. As indicated in the motion, there have been several proceedings with Mr. Kane. Most importantly, there was a landlord-tenant proceeding that was conducted before the Honorable Millicent Sherman. There was a hearing in which the possession was adjudicated, but what is most important is that the counter defendant, or I'm sorry, the
Other side.
the defendant counter plaintiff, Elizabeth Street Lofts, had witnesses present to indicate that Mr. Kane, who was a tenant at the property, had thwarted any efforts to make any repairs at the property, not only with the staff of the plaintiff at the time, Elizabeth Street Lofts, but also with city inspectors, and had witnesses available to testify to that. Now, granted, I would acknowledge that the issue of possession typically wouldn't consider some factors such as repairs and maintenance. However, Mr. Kane, who has filed 3 subsequent motions in that landlord-tenant case, none of which got served on me or my client, has consistently raised issues with the condition of the apartment, although, as indicated, he refused to allow maintenance in and refused to allow the city inspector in. So whether or not that issue has been adequately adjudicated, I would say in consideration of moving forward at the time, even though we had witnesses present, we gave Mr. Kane more time to vacate the property to January 31st of 2023. An additional, I believe, 45 days, more than required. In fact, after that, he filed 3 motions before Judge Sherman, which I believe probably raised issues similar to those he raised in this questionable complaint that he filed before this court, because as indicated in the ROA for the landlord-tenant matter, he presented photo evidence. So he's consistently raised issues about the condition of the property. And so frankly, I feel like it has been adjudicated. It has been raised. If his counsel at the time did not opt to file a counter complaint or an answer to the original landlord-tenant complaint, I guess that's neither here nor there, but it's clear to me that it's been adjudicated and it should have been raised at that time. So I would ask the court to dismiss this matter.
Let me have I have a couple of procedural questions to make sure I understood what you told me. Am I correct in my understanding of what you said, that the various people that you had listed as being available to testify concerning access to the property, none of them did? The matter was resolved by a simple possession decision to give him 45 more days.
It was resolved with the possession decision.
And so those witnesses did not in fact testify at the trial.
No, but Mr. Kane was represented by counsel.
Yeah, but
And-
the point I'm making is those witnesses, although available, did not testify.
Absolutely
And
correct.
the parties resolved the case, which was a possession case, by a consent order. Is that correct?
By consent order as a hearing, not as a consent.
After the consent order was entered, the individual filed various motions relating to the condition of the property.
I believe they related to the condition of the property. He never served me any of the motions. The only way I was aware of them is through the ROA.
Okay, you represented Elizabeth Lofts in the landlord-tenant division.
Correct.
And so since you were never served with the motions, in essence, they're wasted paper. Let me hear from Mr. Riddell.
Your Honor, I was not the attorney in the summary proceedings case, but I do think that the case that governs this is the King v. Monroe case that I cited. That was a case in which in summary proceedings, the tenant raised a mold issue and other maintenance issues. The summary proceedings judge adjourned for, I think, 45 days, basically to do discovery. And then at the date of what would have been the trial, this was pre-COVID times, the parties entered into a consent judgment that only dealt with possession. And that case, King v. Monroe, holds that the tenant did have the right to sue for the mold issues in a separate court because res judicata did not apply. The Court of Appeals also addresses collateral estoppel, but for the same reasons says that collateral estoppel does not apply. And so in this case, as far as I can tell from talking with my client and from the ROA, it does appear that there was never a fact finding by a judge or a jury on the issue of repairs. And so for that reason, I think that King v. Monroe controls this case and would suggest that this case should proceed.
Ms. Madden.
The response I have to that, Your Honor, is the case cited by fellow counsel relates to a negligence claim of not damages to property, but the person claimed that they were physically damaged by mold in the apartment. And again, Mr. Kane filed a complaint that basically I couldn't even read it, although fellow counsel did forward a copy to me yesterday that I could read. And the only claim that I see that would even relate to anything that would be sufficient to claim against my client was that there was a fire in the apartment above that damaged his property.
Okay.
So I think that can be distinguished from the case at hand about negligence from mold causing actual physical damages to the person that would provide, the finding that res judicata did not apply, because that frankly would not have been a good venue to raise the fact that mold had, affected her physically as opposed to items in her apartment.
Okay. I'm prepared to rule on the case. I think that Mr. Riddell's position is supported by MCLA 600-750. We have to remember, 5750. We have to remember that this is a summary proceedings case. I agree that the ordinary rules of res judicata would provide that a prior litigation would cover not only the issues which were actually litigated, but which could have been litigated. But I think the statute here is pretty clear. The remedy provided by summary proceedings is in addition to and not exclusive of other remedies. The Supreme Court told us MCLA 600-5750 evidences the legislature's intent that summary proceedings for possession of property be handled expeditiously. Plainly, the legislature took those cases outside the realm of the normal rules concerning merger and bar in order that attorneys would not be obliged to fasten all other pending claims to the swiftly moving summary proceedings. Were this the case where you had been in something other than summary proceedings, I think your position would be sound. But I think the Summary Proceedings Act itself makes it clear that the remedy provided by summary proceedings is in addition to and not exclusive of other remedies. A judgment for possession under this chapter does not merge or bar any other claim for relief, except that a judgment for possession after forfeiture of executory contract, yada, 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 which is obviously not applicable here. For those reasons, the motion to dismiss will be denied. So where are we on this file, people?
Your Honor, we had an opportunity to start talking last week and had a verbal conversation this week. We've started talking about settlement. As you probably have noticed, I'm new to this case, so I think our goal would be to send out one round of written discovery, and I will just say that I'm open to some kind of ADR, and I would ask that we have a pretrial set just outside of the written discovery time. I can get a set out tomorrow.
Well, what I'll do then is I'm going to give you a pretrial date of May 2nd. Does that work for everybody?
That should be fine for me, Your Honor.
Mr. Riddell?
Your Honor, I currently am scheduled to be in a trial starting May 2nd. Is it possible we could do the week after?
Do May 9th, if you could do that.
I think that'll work.
Is that okay?
Your Honor, I think I might.
That works for me. I couldn't hear what Ms. Madden said.
She's checking.
That should be fine, Your Honor.
Okay. Then here's what's going to happen. We're going to set you for pretrial May 9th, 2023 at 11 a.m. You may zoom in early 10 o'clock if you wish, Ms. Madden, but don't call the case itself.
I checked too, because I thought it was 10 o'clock too.
And your written discovery is open.
Your Honor, I would like to just raise a few things before we
Please.
them off. The pleadings, the original complaint raised several issues and also indicated that there was an attachment. And I did raise in an earlier pretrial that I didn't receive an attachment. And I don't believe fellow counsel has that attachment. Also, I will be asking fellow counsel his consent to file a additional counter complaint, given the fact that Mr. Kane didn't vacate the property as directed, and we had to pay a court officer and a few more months of occupancy before he did leave. So I will have a counter complaint. So I don't know if that affects whether or not the court wants to hear it on May 9th or not, but my intention is to file some more motions as it relates to the complaint, because I just received a legible copy of the complaint yesterday. And also I'd like to receive that attachment that was with the original pleading. So I don't think this is a case suitable for ADR. I mean, we're standing firm on Mr. Kane, who owes us a bunch of money and has been very disruptive. And I don't think it would benefit, and I'd ask the court not to consider ADR on this.
Well, we're not really at that point.
Okay.
Okay, we're not really at that point. It seems to me that before we make that kind of decision, we want to make sure our procedural posture is correct. We're still working on that. Then we want to make sure that we have done our written discovery, because one of the things I don't want to get into, if I can avoid it, is the expense of depositions. Depositions are very expensive, as you know, and it seems to me that the facts here probably can be fleshed out by way of written discovery. When we get our written discovery done, maybe it's right for summary disposition, maybe it isn't, I don't know. But it seems to me that we're way before the time where we really want to be making the call as to yes, we do ADR, no, we do ADR. Because I always, let's say for purposes of our discussion, let's say we get to a point where all these things have been done and nobody is really at a point where we can settle. Maybe that's the case to go to case evaluation, so that there'll be some teeth and sanctions available for the prevailing party if the case goes on. But I just think at this point in time, we're a little bit early in the day to make that decision. And I prefer to make a decision when I get to a decision point.
Very well.
I will see you guys on May 9th at 11 o'clock. Your written discovery is open, and I'll send out an order for that today. Also send out an order denying the motion to dismiss for the reasons set forth on the record. So, Mr. Riddell, if you could get her those attachments so we could get ourselves moving here. You guys, you can do any, if you want to do counterclaim or whatever, you can do that by stipulation without the necessity of a motion. Indeed, the court rules require that you seek the concurrence of the other side before that occurs. So, ballpark figure, and I'm just ballparking, how much is your claim going to ultimately be?
Within this court's jurisdiction.
Okay, it's not going to exceed my 20 foot. That's what I'm interested in. Because I keep finding myself with cases that are one day $7,000 cases, and we come back and you're $30,000 cases. Don't know how that happens. Okay, May 9th at 2 o'clock. Thank you. For coming.
Thank you.
Perfect, thank you.
I'm sorry, 11 o'clock, not 2 o'clock.
Yeah, we knew, we got it.
Appreciate you coming in.
Have a good day.
You too. Ms. Francis,
Good morning, Your Honor.
what file do you have today?
I'm here for credit acceptance ending in 695.
Yep, I think I have Ms. Bryson. We can get started. Hello? She's still connecting to audio here. She's still connecting up. Hello?
Hello.
All right, we are on the record calling file 22-184-695, Credit Acceptance Corporation versus Monique Bryson. Your appearances.
Good morning, Your Honor. Sandra Francis on behalf of plaintiff P74229.
And what is your name, ma'am?
Monique Bryson.
What's going on this file? I was told on March the 7th that there was supposed to be a consent judgment. What happened?
Yes, Your Honor. Back on February 7th at the initial pre-trial, we had agreed to a consent judgment. It has not been returned by the defendant. Then we've sent it to her a few times after that, and it still hasn't been returned.
Ms. Bryson, what's going on?
I wasn't aware I was supposed to send it back.
Okay, I'm done with this. You failed to appear at the last pretrial. I'm going to set this motion for summary disposition for hearing. Either you folks will have a settlement or I'll make a decision on the motion. You can't have a settlement if you aren't going to participate, ma'am.
I will participate.
This is April. You've had that since February.
I didn't know where I was supposed to send it back to. I didn't know it. It wasn't nowhere on there.
You send it to the person who sent it to you, ma'am. That address and name are on the pleading at the top of it. So what I'm going to do is I'm going to calendar for May 2nd at 11 o'clock. Plaintiff's motion for summary disposition. If you get the matter settled before that time, I'll be happy to have the consent judgment. This case is not going to be allowed to continue to just drift here, which is what's going on here now.
And Your Honor, I just want to indicate to Ms. Bryson that if she received the consent judgment in the mail, it does include a return envelope. If you do have any questions regarding the consent judgment, you can reach out to our office.
You said I can't do what?
You can reach out to our office if you have any questions, but it did include an envelope on there for you to return. You just simply have to sign it, put it in the envelope and put it in the mail. Or if you'd like to fax or email it to us, you can also do that as well.
Okay, thank you.
Okay, I'll send out that scheduling order today. Thank you for coming in.
Thank you, Judge. Have a nice day.
You too.
Thank you.
Thank you. Katie Burrell. Tiffany Sewell. 604. Good morning.
Morning, Your Honor. How are you?
I'm good. How are you?
I'm doing well.
And you're here on Consumer Power?
Yes, Consumer Portfolio versus Tiffany Marie Sewell.
Okay, I'm trying to wait to her to connect to audio. Now we got, hopefully can get started.
Okay.
Still waiting for her to connect.
Okay.
I'm gonna put her back in the waiting room and try it again.
Okay.
Hello? I think I got her now. Hello?
Good morning.
All right, we are on the record. This is file number 22194604, Consumer Portfolio versus Tiffany Sewell. Date and time for what appears to be a pretrial. Our discovery is now closed in this matter as of April 1st. Could I have your appearances?
Attorney Franco Barilli, attorney for Plaintiff Consumer Portfolio Services.
Member of the State Bar of Michigan,
P69468.
and your name, ma'am?
Tiffany Sewell.
Where are we on this file, people? Our discovery's closed.
Yes, Your Honor, we just got into an agreed entry. We sent it over to Ms. Sewell. We did receive it back. It's awaiting my signature now, and we will be mailing this over to the court to close this matter.
Okay, so the parties have signed closing documents, and the court is just looking forward to your sending them over. Is that correct?
That is correct, Your Honor.
All right, the court will dismiss the matter on your representation as an officer of court. Note that closing documents are coming.
Yes, it'll actually be an agreed judgment entry.
So it's
it
a
will be-
consent judgment, would that be it?
That's correct. That's correct.
Okay, we'll dismiss it without prejudice, noting a consent judgment to follow.
Okay.
All right, thank you both for coming in. Let's be safe.
Thank you, Your Honor.
Thank you.
Ms. Brown? What is your name, ma'am?
Okay, there we go.
Okay, Ms. Brown, I'm in the middle of one more case. I just want to let you know I knew you were here.
Okay, great. Thank you.
What is your name, ma'am? Hello?
Hello,
What is your name?
John Kane.
Mr. Kane, what brings you here today?
I have a court date today, Your Honor.
Mr. Kane, we already heard your case. Your lawyer was here. We got started. We're done.
My case wasn't until 11 o'clock. I've been waiting here since 10 minutes to 11.
Under the name of Danita Watson.
Right. Yeah, that's my name. Yeah.
But I've been here. Nobody let
Under
me
the
in the
name
meeting.
of Danita Watson, who is not listed
that's me,
on the
yeah.
docket.
That's her right here. She's here, right there.
But sir, when I'm looking at my waiting room, I don't see a party, John Kane. I see a Danita Watson.
I don't know
That's the
why
name
they
that
did
you're
that.
listed under. You can
My
check with
name- my
Mr.
name-
Riddell. He can tell you what's going on. Thank
Well, it's both of us are on the case.
Again, sir,
This is-
you can check with Mr. Riddell. I can't have an ex-party conversation with you. Thank you.
Who is Mr. Riddell?
Mr. Riddell is your lawyer, sir.
Oh, Sean Riddell. Yes, yes, sir.
Yes, sir. Thank you. Fucking- Mr. Cox?
Good morning, Judge.
I think we're about trying to get started with your litigation here. Let's see if I can get these folks admitted. This person I admit. Admit this person. I presume this is 3. I'm waiting for 2 more people here. Let's see who they are. Hello?
Hello,
What is your name?
my name is Joelle Wright Terry, Your Honor.
And you're here on which file, ma'am?
Appearing on behalf of Memorials by Marsha Sassy with
Yeah.
Ms. Tria Brown.
Okay. I've got one more matter to get before I get to you. I've already talked with Ms. Brown. She's in the waiting room. I'm going to put you in the waiting room as well, okay?
Yes, sir.
I just want to let you know I knew you were here.
Yes, sir. Thank you, Your Honor.
Yes, ma'am. So this should be Octa Plus, and that should be it.
The 3 plaintiffs in our case are present. Nina, Devon, and Edidion, that person you just allowed into the room is not on our case.
Oh, you know what? That's someone who's from another case. Let me remove him. Octa plus remove. Okay. I think I have everybody. I have 1, 2. All right, let's call your case. I'm going to butcher these names, so I apologize for that in advance. This is file number 23-140-446. Devon Burt. Devon Burt, are you here?
Yes, Davon Burt.
Okay. Turn your video on, would you please? Ididong Adkapan, are you here?
I'm here.
Okay. Nanina Amuchi, are you here?
Yes, I'm here.
Okay. And your appearance, counsel?
Good morning, Your Honor. Aaron Cox, P69346. I'm appearing on behalf of the defendant counter plaintiffs in this matter.
Okay. I have all the 3 parties, plaintiffs, and I have the defendant. Before we go any further, I'm going to issue a decision on a motion for reconsideration. As you know, motions for reconsideration are heard without oral argument. We were last together on this file back in March of 2023, and the court denied a motion for reconsideration, denied a motion to consolidate based upon there being both, as I understand it, a pending possession case in the 36th District Court Landlord Tenant Division to be heard April 11th, and this case, which is a claim for money damages. The plaintiffs filed a motion for reconsideration. A motion for reconsideration under MCR 2.119 F1 provides, and I'm reading from F3, generally and without restricting the discretion of the court, a motion for hearing or reconsideration, which merely presents the same issues ruled on by the court, either expressly or by reasonable implication, will not be granted. The moving party must demonstrate a palpable error by which the court and the parties have been misled and show that a different disposition of the motion must result from the correction of that error. In this case, the plaintiffs cannot demonstrate palpable error, which must have a different result in the decision of the court. 2.505 is the rule that governs consolidation. The rule, let's look at the rules again. MCR 2.505 provides that the court may consolidate. The court rule further provides in subsection B that the court may separate the claims. So there's no palpable error here. Further, I would point out that this case that was being discussed pending in the landlord-tenant division is pending in the landlord-tenant division. This is a summary proceeding. That should I say that case is a summary proceeding. MCLA 600.5750 provides that you may bifurcate summary proceedings from other remedies. The Supreme Court has observed MCLA 657.50 evidences the legislature's intent that summary proceedings for possession of property be handled expeditiously. Plainly, the legislature took these cases outside of the realm of normal rules concerning merger and bar in order that attorneys would not be obliged to fasten all other pending claims to the swiftly moving summary proceedings. The statute itself specifically provides that the remedy provided by summary proceeding is in addition to and not exclusive of other remedies, either legal, equitable, or statutory. It further goes on to provide that a judgment for possession under this chapter does not merge or bar any other claim for relief, except that a judgment for possession after forfeiture of an executory contract for the purchase of premises shall merge and bar. So there is no palpable error. The statute specifically allows for the separation of claims for possession, claims for damages related to being the landlord-tenant act, and in any event, the question of consolidation is discretionary with the court. For those reasons, the motion for reconsideration is denied. Now, where are we on this file, folks?
Your Honor, the only summary that I have from the last time we were before you is that both parties have issued discovery in this case. I'm satisfied with our discovery at this point. I think the only thing that my client needs to do from here is file a motion for summary disposition. And to the extent that's not granted, schedule a trial date.
All right, let me hear from plaintiffs. Let's start off with Plaintiff Burt. Is there anything you want to tell the court?
No, we're gonna,
I can't hear you.
I'm saying there's only one person that's gonna be speaking, so I'll pass it to the
Well,
person.
wait, let's stop right here. None of you are attorneys. You may not speak on behalf of another person. In the Michigan courts, in the general civil docket, now maybe you can in small claims, but not in general civil, unless you are an attorney. So the first thing I want to urge all of you is to get a lawyer, because apparently you have some notions of what the law provides that are not consistent with what most of us understand Michigan law and landlord-tenant to be. So let me ask again, Plaintiff Burt, is there anything else you wanted to say to the court today, sir?
I mean, it's not sir, her pronouns are in the profile, so if we can be, please.
Plaintiff Burt, is there anything you wanted to say to the court? Court, excuse me.
No, I'm fine.
Thank you. Plaintiff Adkapan, is there anything you want to say to the court?
Not right now, but I would like Nina to get a chance to speak.
You have a chance to speak now. Please speak.
I've spoken and I said I don't have anything to say. I will just
okay.
let Nina speak. Thank you, Nina.
I understand. Thank you. And Plaintiff Amucci, is there anything you wanted to say?
Yes, so there's one thing that the defendant said about filing a written discovery. It has not been filed as of today. There's no written discovery filed with the court, and this is part of the issues that we raised in our motion to reconsideration. Aaron Cox and their defendant have consistently filed late motions or not responded to motions at all. So that was one of the things we even brought up in our motion for reconsideration, that at the time of March 7th, there was no response to our motion for consolidation from Aaron Cox's office, and there has not been any documents filed with your court around written discovery. So we're a bit confused on our end why there are documents that are being spoken of in court today that have not been filed with the court. If you can check with your documents, because
I think one thing needs to be understood. In discovery, now you folks filed plaintiff's first discovery request. The only discovery requests that need to be filed with the court are requests for admissions. Interrogatories, requests for production of documents are not typically filed with the court.
Okay, so there has not been anything at all filed from Aaron Cox's office. And again, this has been a consistent pattern with Aaron Cox that they do not file or respond to any of our motions. The last thing that they filed was in February, so they never even responded to our motion to consolidation, and they have not filed anything with the court since February. That's something that we have brought up consistently. There's something improper going on behalf of Aaron Cox, where they're coming to court and claiming that they have certain documents before you, and you're reading documents that are not filed in the court and that we don't have in our possession.
I read from the opinion that I wrote in response to your motion for reconsideration. That was my time and research, not Mr. Cox's.
No, agreed with that. I'm agreeing with that. I'm saying that in our motion for reconsideration, one of the things we brought up was that there was no response or answer to our motion to consolidation. So I'm just noting a pattern of there's not anything filed within the court. So we're a little confused as to how do we respond to things that are not filed within the court and that have not been mailed to us. That has happened several times, including Aaron Cox today just said that he's satisfied with his written discovery, but there has been no written discovery filed with the court. And maybe he can speak to whether or not there has been a request for admission that has filed. But regardless, today we looked in the docket and there has been no documents filed on behalf of the defendant in the court since February.
Mr. Cox?
Well, Judge, I'll try and address all of the baseless allegations that were just levied. We did in fact file a response to the motion to consolidate that was filed and served on the plaintiffs on February 23rd. The court's ROA reflects that it was received by the court on March 6th. I personally prepared and mailed our discovery requests to the plaintiffs on March 7th, shortly after our last pretrial. As the court's already pointed out, I don't have to file those documents. I can mail them, and I did. And I mailed them to the addresses indicated in the pleadings. I don't have to file them. It's been done in accordance with the court rules.
Okay, so to confirm, you filed, did the written discovery that you sent to us, was there a request for admission in that document?
Requests for admissions are filed with the court.
Yes.
And at this point, there's no filing.
Okay, so Aaron Cox, did you file a request for admission with us? Did you send that to us? Because again, none of these documents have been filed with the court. And I'm going to actually check in the court docket right now for what you named about February 23rd, because we don't believe that there was any response to the motion to consolidate in the court's docket, because we have looked at it multiple times. I'm going to look in the document.
Ma'am?
Mm-hmm.
I'm reading from a document that is stamped March 6th, and it is entitled Defendant's Response to Plaintiff's Motion for Consolidation. And it is signed by your side.
Yes, I think we filed an error. We filed a document that was an error. So that was not, we actually looked at all
filed an error?
But we actually looked through the whole docket last week, and the last thing that Aaron's Cox filed was February 7th, I believe, or February. Let me look at the document again. February. Yeah, there was an error on the court clerk because they put it in as defendant, and we went back to correct the error, but they said that you had the documents and we could not adjust it, and so we wanted to address it today.
Let me get again. I'm reading from my file.
Yeah, you can look through your file. You'll see that.
Excuse me.
Oh, sorry. Go ahead.
There's a stamped plaintiff's response to motion for consolidation. It is stamped here February 28th, signed by Mr. Cox's office. So apparently we have a failure to communicate here, because some of the things that you were saying, ma'am, are not factually correct. Let me urge you all to consider getting counsel. I think you would be well served by that, but let me also point out that you have an absolute constitutional right to represent yourselves. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. You would be well served, in my judgment, to get counsel, but again, you are not required. You have an absolute constitutional right to represent yourselves. So the motion for reconsideration is denied for the reasons set forth on the record. Your next date with me will be May 2nd at 11 o'clock.
Thank you, Your Honor. Can I have one more question?
Please don't interrupt me.
Sorry.
I would suggest that you get going on your discovery. You want to say one more thing, please.
Yes. So again, I understand that you said I named something false. I just want to set for the record that Daniel Cox had claimed that they filed a written discovery that included a request for admission. and that has not been filed with the court. So is that something that you can verify on your end for the record? Because we have not seen it in the court that there's been any written discovery filed, just because, again, there's also false claims that keep being made on their end. And we want to just have that can you check if there's been a request for, like Aaron, has there been a request for admission? And also I just want to name, though I'm not barred in Michigan, I am an attorney. So we are trying our best to understand the laws of Michigan. But I have a history of being barred in California and also barred in Washington, D.C.
And the laws in Washington, D.C. are federal,
different.
and the laws of California are much different. For
Absolutely.
example, and not by limitation.
Absolutely.
Michigan law does not recognize a right to extend a residential lease or a commercial lease. California law apparently does. The laws are very different here.
Absolutely. I just want to name that because, I hear you saying, I just want to name that we do have experience and expertise, and we are here trying our best to communicate with the court. And if you can look through our documents, we are doing a very good job of our legal analysis and our fight in this court. And so I would appreciate that same level of honor and respect in the court.
Have I spoken to you without respect, ma'am? Excuse me. Have I spoken to you disrespectfully?
I'm just saying that we would appreciate that on our end.
Have I spoken to you without respect? Have I disrespected anyone in this litigation?
There have been misgendering. There have been different phrases where there have been deference to Aaron Cox in ways that have dismissed what we're saying. That happened last time when we said we didn't have any pleading errors. We said that we actually have filed an amended complaint and it was before your court, and you kept telling us that it was not. And then you asked Aaron Cox whether or not he did it, and then he confirmed what we already confirmed.
I asked him whether he had it.
Yeah, no, you asked him whether. Yeah, but we already named what happened, and then you asked him to confirm what we already knew to be on record. And so there has been a pattern of, because we're not attorneys barred in Michigan, we feel like there is some level of prejudice or disrespect that is coming our way because, we are filing things on time. We are doing the things that are necessary, and we would just appreciate that same honor and respect as people who are facing eviction and who are facing retaliation. And so that's what I'm offering, is that there are things that you are deferring to Aaron Cox because he's an attorney that we already have said and filed. We are filing and we're responding at the same pace as he is. And so we deserve that same level of respect and honor before your court as a fair and just as you are committed to justice and fairness. I see your banner in the back that says Association of Black Judges. We respect and honor you. And so we hope that that same level of respect is owed to us. And we're not just deferring to Aaron Cox because he is an attorney in Michigan who represents property managers and other forms of corporations. We understand that we are, up against a lot, but we would appreciate that same level of respect and honor to us, even if we are not barred in the state of Michigan, because we have been holding our own in this court. And you have our documents before us. So we understand some level of the law, and we understand some level of what we're doing.
Mr. Cox, anything for you?
Judge, I would just ask, instead of May 2nd, if the court wouldn't mind adjourning that out to maybe a later date in May or even into June. I intend to file a motion for summary disposition promptly, but I need time in order to do that and adequately notice it.
Well, let's go with May 2nd because we have till we get our discovery done. Any motion for summary disposition is premature anyway.
Yeah, and that's part of the issue, right? There is a lot of evidence of retaliation in this case, and he continues to offer up motion to summary judgment.
Let me ask a factual question here.
Mm-hmm.
How many written leases are there?
So there is a lease that the plaintiff signed on December 2021, which again,
is there a second lease or not?
No, there's just only one lease.
There's only one lease.
Mm-hmm.
Let me ask another question. The lease that was signed.
There are multiple leases, I'm sorry.
Oh, there are multiple leases, sorry. There are multiple leases from 2019, from 2020, yes. From 2021.
All right,
yes.
The last lease was signed in 2021, is that correct?
December 2021.
And what was there? Was there a period of time for that lease? Was it an open-ended lease or did it have a lease for a period of time?
It's an annual lease since 2017.
No, I'm asking about the last lease.
Mm-hmm.
Was it for a period of time or was it open-ended? That's what I'm asking.
It's for a period of time from December 2021 to December 2022.
All right, so after that lease signed in December of 21, there are no more signed leases. Is that correct?
Yes, because usually the lease is supposed to end October 31st, but they actually delayed it and gave us the lease in December 2021.
Okay.
But they actually they retaliated and entered into eviction before the end of the lease, claiming that the lease ended October 31st, even though the lease ended December 2021. So there's already improper things happening beforehand, because the lease didn't end October 31st, but they keep claiming October 31st, even though the last lease was signed in December 2021. So there's no way a yearly lease can end October 31st if it was signed December 2021.
Okay. We will
That's
see.
part of the retaliation that we've been facing for months, for years. We've been facing a lot of retaliation over and over again for exercising our rights. And so they're trying to get it out of the way, but there's detailed documented evidence of a series of retaliation. Again, the lease did not end October 31st because the lease was signed December 2021. So there's no way that you can enter into an eviction and say that our lease ended, and you moved us to a month, and then you claimed our lease ended October 31st, but you also accepted our November rent, and you also accepted a new tenant in November. So there's so many contradictory things that they're trying to just move this along, because they know that there's ample evidence of retaliation that we have been facing for months, and we continue to face this retaliation.
Okay, we'll see you all May 2nd at 11 o'clock. Your written discovery will continue, and I'll send out an order denying the motion for reconsideration. Thank you all for coming in. We're off the record.
Thank you, Your Honor. Have a good day, Judge.
You too. Okay. All right, let's get everybody on it. All right, we are on the record. This is 22-243752. Tara Brown versus Marsh and Sassy Monuments. Could I have your respective appearances?
Tria Brown, the plaintiff.
And your name? Ma'am?
Yes, Your Honor, Joelle Wright Terry, but however, my business name is Memorials by Marsh and Sassy.
Okay, now here's the situation. Have you folks been able to settle the case?
No.
Okay, well then, I really can't go further here because the defendant is a corporation, correct?
That is correct, yeah.
I'm sorry.
Corporation must be represented by an attorney. I thought you folks had worked it out, so I was trying to avoid that expense, but apparently you're not able to do that. We were in small claims. In small claims, it would be okay for you to represent your organization. But as soon as the file was removed to general civil, which is where we are now, you got to have an attorney. So what I'll do is I will adjourn the matter May 2nd at 11:30. And you're going to have an attorney file the appearance. The appearance is the document by which he or she will be representing. So we'll see you May 2nd at 11 o'clock.
Your Honor, may I ask a question, sir?
Ma'am?
May I please ask a question?
Yes, ma'am.
So as it relates to me retaining an attorney on behalf of Memorials by Marsh and Sassy. The court is stating that it's Marsh and Sassy. Marsh and Sassy is no longer in existence.
Well, if Marsh and Sassy is no longer in existence, then maybe the case will be handled differently by the attorney. I don't know.
Okay.
I can't give legal advice. But the only thing before me now is that a case that started in small claims where the defendant could be represented by a layperson. But now the case is removed to general civil. I gave you an opportunity to settle the case because I thought you two were talking about resolution. Apparently that did not happen. So we'll see you May 2nd at 11 o'clock, 11:30, and the defendant will have to appear by counsel. Thank you for coming in.
Thank you so much, Your Honor. Have a great day.
Send out an order. Let's be safe out here.
Thank you.
Hello? 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 That concludes the morning call.